When starting a family law case, should I get a new email address? Are there any risks to using an email account that I already have? Are there any benefits to establishing a new email account? Those are the things we're going to talk about today. I'm Michael Miller. I'm a partner at Cole Miller, PLLC. We are a family law firm located in Vienna, Virginia, serving primarily in the Northern Virginia area. I analyze challenges and provide affordable solutions to families and their family law needs. So today, with regard to emails, back in the olden days, there used to be one computer that the family shared, and you'd be surprised at the number of calls that we would receive, especially on Monday mornings, where clients had either found their spouse's email account on the shared computer or the downloaded email files, or the clients who would call up to let us know that their spouse had found out about the communications with the paramours and so forth. So one of the things we started doing was to recommend against using shared email accounts and so forth. And so by establishing a separate email account, you build in one layer of security, because now the other party won't know what that email account is. And then you have the second layer of security, which is the password. And again, for the passwords, don't use names of children, names of dogs, birthdays, and things like that as your passwords. Get a completely different password. The idea here is to prevent your communications, especially with your attorney, from being compromised or being discovered by the other side. So there are laws against hacking into people's accounts or accessing their emails and so forth, but an ounce of prevention is worth a pound of cure. Now, one thing to consider is if you engage in a family law case, there may be what's called discovery. One of the things of discovery is you ask for document production from the other side. One of the requests for documents could be print out all your emails or something like that. The risk you run if you're using an email account provided by your employer is another form of discovery, which would be a document subpoena. So if you're using your employer's email account and all your attorney-client communications are on that account, you run the risk that a subpoena could be issued to your employer, and then your employer would go to the email server, pull off all your emails that would then disclose communications that you've had with other persons, possibly including your attorneys, about the conduct of your case. So a big problem there. Second problem to that is the employer's email account should be used for the employer's business, so they may not be happy to find out that you're conducting personal business on a employer-provided email. As I said, during the course of your case, there will be attorney-client communications that you'll want to maintain as private or confidential. And so by having a separate email account, you can more easily isolate those emails, so that if you do get a document request to produce all your emails, one of the things your attorney can do is provide a privilege log or a confidentiality log identifying those emails as not being subject to discovery because they're confidential or they're privileged communications. And it'll be a lot easier to do that if those are kept segregated from your general run-of-the-mill emails where you're talking to your friends and family and so forth about personal events and stuff coming up. By having a separate email account, it will make it easier for you to follow along your case. During the course of your case, you will receive numerous emails from your attorney, and the emails themselves may have information about upcoming trials, responses from the other side, things to work on, and they'll also have attachments to them of documents. There could be draft settlement proposals, responses to settlement proposals, pleadings, answers, complaints, discovery, and things like that. So if your emails related to your case are kept in a separate account, it'll be a lot easier for you to follow along and access those and refer back to those emails if they're not mixed in with all the things about parent-teacher meetings and car repairs and things like that may be coming up. With regard to protecting the emails, probably don't need encryption. If both sides can set that up, if the attorney's office can handle that and you can work with that, there's no detriment to it. I've not in my experience, found it to be useful, oftentimes because, especially with two-factor encryption, trying to keep track of everybody's public and private keys and so forth becomes more trouble than it's worth. If there is a concern about the contents of a document being revealed, you could look at using a password for that. So if you let your attorney's office know, this is the common password that I want to know or want to use, then they can encrypt, statements or Word documents or PDF documents or things like that they send to you. Also, with regard to communications with the other parent, especially in custody cases, it could be beneficial to have a separate email. This way, your communications with regard to your property settlement, the communications regarding your support determinations that could be heated and controversial between the two of you can be kept aside, and you can have one account that's just dedicated for you and the other parent to talk about matters of custody, making arrangements to get the children to their events, upcoming medical appointments, and things like that. Again, having a separate account will make it a lot easier because at some point during the conduct of the case, there may be allegations that one parent's not informing the other parent, that you haven't been sharing information, and now with that email, you have the documentation to show that you did send notice of the appointment to the other parent, or you did inform them of the doctor's visit and the results of any kind of treatment or checkup or something like that. Also, by keeping a separate email account with the other parent or your spouse for those limited matters will keep you from cross-posting emails that you intend to your attorney. It happens with regularity that you get caught up in trying to communicate with your attorney on one hand, trying to communicate with the other spouse on the other hand, and the next thing you know, the lines get crossed up. Even worse yet is then the other side starts communicating directly to the opposing attorney, which causes all kind of problems. So again, don't do the cross-posting. Don't CC your attorney on communications from the other side. Try and keep everything isolated and separated from each other. So keep your attorney-client communications in one account away from the other side. Keep your communications with the other side in a separate account. And that will help to protect your communications, keep private matters and confidential matters private and confidential. The last thing to say about email accounts is they are preferred to using chat to keep track of your custody discussions and your child-related matters and things like that. There's, going through several months of emails by themselves is difficult enough when the threads are mixed in with each other and you're having to read them in reverse. And in some cases, the previous emails have been CC'd or resent back in reply. Sometimes they're cut out. But the chats are really the worst to work with because oftentimes we get them as individual screenshots. And so you have the tail end of the last comment, then you have the comment, and then you have the first line of the next comment. And so you end up with 63, JPEGs that you're trying to piece together to find out that it was just a simple, 7-sentence exchange between the parties. Also, it's hard to keep track because they may be in color when they're on the phone, but then they get put into black and white when they get copied onto paper. So chat's very cumbersome to work with, very inconvenient. Email's preferred for that. So those are a couple reasons why if you're starting a family law case, you would want to consider establishing separate email accounts for matters of privacy, confidentiality, to make discovery easier and to make communications with your attorney easier.